Do I recall that? No.
Okay, would it refresh our recollection to see a clip of that bench
Sure.
conference? All right, we're going to, I believe it's 511.3, Defense 511.3.
Oh, please don't. I'm trying to get this done. I'm very frustrated. Gabe, come here.
I'm going to talk to him.
Come here. Come here. You're lucky my head's not spinning off its axis, okay?
I got to get through this transcript.
Okay, I understand.
I'm almost
It's
done.
the manner in which it's being done. It's driving me absolutely wild. And it's driving me wild. It's driving them wild. So whatever you're trying to do, it's being lost in the manner in which it's being done. Just don't say anything right now, please.
Can I excuse the defense witnesses till, say, 1:30?
Well, I'm afraid because I don't know how much longer he has with this witness. And then I don't know how long he's going to have with this witness. And I don't know how much longer he's going to have with this witness. And I got the jail downstairs holding Beardsley. So
And we're quitting our way.
And
At least that's what the plan was.
I'm trying to quit early. But I mean, to tell, no, we're not having him come back on Wednesday. And if I have, whoever he was talking about. Who do you have besides Beardsley?
Well, I have 4 witnesses. I have Officer Tucker, I have Detective Hunt, which is the information I was going through the other day. I'm calling Mr. Beardsley and Tom Scotto.
What did you want to add to this?
Well, I just think, I think it's a time saver. There's a difference between asking witness if they hear something or not as a witness, and then trying to treat it like it's a laboratory in the courtroom. Really, when you play something and you want to hear something that's selling, you need to have headphones, you need to be in an environment with good equipment. It's treating it like it's a lab.
It's totally lost on everybody. So we'll continue to do this. We'll continue because that's what you want to do. Go right ahead. I'm going to let you do it. But as far as your witnesses,
And that was 10:17. It stopped at. It began. It's 9:29:08. Jabs beginning at 10:15:49 and stopping at 10:17. Recall that painful bench conference?
I do now.
Okay. And so, do you recall that Judge Glass was pretty upset about the way the evidence was coming in?
Yes.
Okay. And do you recall Mr. Barnett having his talk with you after that and saying, what's going on? How come that's, why are you putting the evidence on this way? And you telling him, I haven't had time to do anything. I'm doing this at night with my son. And do you recall that?
No, that didn't happen.
All right.
I mean, I can tell you that in my experience, first of all, if you've tried as many cases as I have, that's pretty tame, that bench conference. That's not a big deal. Okay. I mean, I've been in federal court where it's like a lion's mouth just opened up when you're at sidebar with some of these district court judges. Okay. As opposed, or even any judge, state court, federal court. I remember there was a judge that would go sidebar and he'd look at you sideways and he had a gun in his ankle. Okay, so I've been in front of a lot of judges that are scarier than Judge Glass was. But the thing about this is the way I look at it from a defense attorney's point of view. I had a transcript that no one had found before. I had a transcript that was making OJ look better. That OJ was making a phone call, like the robber was calling the police after the robbery, right? So I had this transcript, and I thought I was making a lot of headway with it. And one of the biggest clues you get as a defense attorney that you're making a lot of headway in court is when the prosecutor and the judge are all up in arms about what you're doing. So that's how I looked at it.
Okay. So do you
it's
think...
a badge of honor more than I looked at it as, oh my God, I'm being criticized by the judge.
Okay. So you thought your presentation was effective then?
Yes.
Okay. Do you think you might have been able to be more effective had you hired experts to help you?
Had we hired the right experts, we would have known this way before the trial even started.
Okay. And so you still agree that you should have had an expert to assist you with the analysis and presentation of the audio tape evidence.
None of my testimony should be construed in a way to me saying, you know what, I know we didn't hire experts, but I took over and I'm as good as they could have been. I'm absolutely not saying that.
Okay.
What I'm saying is, it all fell into place, you know, it's all sort of falls into place. I was being told by Mr. Galanter, we haven't been paid yet, no money's coming yet, we don't have money for experts, we're gonna have to do this thing on a shoestring, that's why you're not getting paid. You know, now I've learned the whole time, he's getting money out of, what's his name, Skip Taft, the whole time he's telling me that we're not getting paid, that the bottom line was that it was a situation where the money was coming sort of from one source and going into one pot. And so whatever money was gonna be used for experts or costs or investigators was money that Mr. Galanter wasn't gonna be able to keep. Therefore, there were no experts and there were no investigators. And there was no local counsel getting paid. He got blown off too.
Okay, and given that statement, do you feel that Mr. Galanter was acting in Mr. Simpson's best interest as his defense attorney or his own?
I don't think it's in Mr. Simpson's best interest to have had a situation where, in the case of this magnitude, okay, we don't have any help. We don't have, you know, I mean, I remember walking in and saying, what, the state has a jury consultant? I'd never seen a case where the state hired a jury consultant. I'd never seen that before. They had their own jury consultant. Could we have had a jury consultant? Probably could have. But there was no ever any talk about anything extra. It was just, you know, it's you know, look, Gabe, we're in a situation. We gotta do this. We gotta fight the good fight. We're doing this on a shoestring. Let's just go forward and do it. And I'm like, okay, well, I'm gonna have to take over these tapes then. I'm gonna have to do this. I'm gonna have to do that. That's how I saw it.
Okay. And do you agree that Mr. Simpson faced more of a risk than most defendants with respect to unfair prejudice being at trial?
Absolutely.
Okay. And so were you concerned about all of the bad character evidence that was in the audio tapes?
Yes.
Right. Did you ever address that concern with Mr. Galanter?
Yes, the tape should have been objected to from the beginning. We should have, and this was something that I never really understood. The tape should have been challenged from the beginning. I remember doing research on the issue of, you know, audio taping people without their knowledge and things like that, and what the rules were in Nevada and what the federal rules were, and trying to see if we could get Reggio prosecuted in federal court for doing this kind of stuff, or, you know, all that kind of things. I remember looking into that. But for some reason, from the very beginning, it was just something that I never really understood. Yale was like, nope, we're letting the tapes come in. We're not, and I remember Brett Bryson was really big on trying to stop these tapes from coming in. And I was like, okay, well, we're letting the tapes come in.
All right, and did you specifically speak with Mr. Galanter about the bad character references that were in the audio tapes?
I don't believe I sort of picked out bad character references. I just remember saying, shouldn't we consider filing a motion to just suppress all of these tapes? You know,
okay.
You know, based on the surreptitious nature of their tape, and based on the fact that they're not reliable, based on what may have been said in them. You know, whatever we can pick and choose. But my thought process never went further than that, because it was sort of, you know, again, no, we're not going to do that. We're just going to let them in. It's no big deal.
And so you never specifically addressed the idea that the tapes could be redacted to remove the prejudicial character references, but still be played?
No.
As far as the incident goes, or anything else relevant goes?
No, it was a situation where it was, look, this is the deal. This is how we're going to do it. Conversation over. Move on to the next point.
Okay. Well, with respect to character evidence, what's your understanding that the state has to do before they can admit character evidence?
With respect to what, on tapes, or?
Are you aware of the Petrocelli standard?
Yes.
Okay, and what's that?
It's basically that, you know, there's there's what we're known as bad act evidence or whatever, just that the state has to show that it has, for lack of the way lay people understand, that it has some relevance to the trial.
Okay.
That the character evidence, without getting into the technical aspects of it, that it has some relevance to the trial.
And part of that is that it is sufficiently probative and the danger of unfair prejudice does not outweigh that.
Right, the 403 stuff.
Okay. And a Petrocelli motion was not brought by the state in this case, is that correct?
No, it wasn't.
All right.
It wasn't because from the very beginning, we never objected to the tapes.
In fact, you affirmatively were trying to move them into evidence.
Yes.
All right.
I don't know if I was, but the defense was.
In their entirety?
Yes.
All right. And that came up several times. We want the tapes in, we want the tapes in,
Right.
we want the tapes in. Okay. And do you recall that these tapes were played, to the extent that they were played in court, they came up with highlighting each line as the audio was heard.
Oh, yes.
So the transcript was displayed and the lines were highlighted.
Yes.
All right. And so the highlighter was emphasizing what the jury was hearing at the time.
As the words were being said, it was a fabulous setup. And clearly, the state had gone over and above the call of duty in putting together these tapes, which I wish we could have had something like that, but the state had it.
Okay.
And it was very effective because the jury could sit there and watch these big monitor, see the words, and listen to them at the same time.
Do you recall that you had brought a pretrial motion to keep out evidence of the California murder case as well as the California civil case?
Yes.
All right. And do you recall that Judge Glass's rulings on that were fairly protective of Mr. Simpson?
Yes.
Okay. She had said the murder case is out. We're not going into that. And as far as the civil case, it might be relevant if the relevance comes up at trial. It might be relevant, but it's going to be very limited. And if it comes in, it's going to be called a civil judgment. Do you recall that?
Yes.
Okay. And then nothing else is done prior to trial to further litigate the judgment issue.
Right.
All right. And do you recall that when the state did its opening argument in this case, up pops the judgment on a screen?
Yes.
Recall that? Okay. And do you recall after that judgment came up, there was more arguments about the Goldmans during opening argument?
I remember their names coming up.
Okay. I'd like to play some clips from opening argument to see if it can refresh your recollection a little bit on what I'm about to ask you about. Could you play clip 501? And I think it's 501-1.
Another individual that is discussed only hours before, indicative of the mental state of the defendants, in particular Mr. Simpson in this case, Frederick Goldman. There is discussion that you will hear on an audio tape at the pool of the Palms Hotel and Casino, where some of the Confederates and the co-defendants gathered to discuss how they were going to commit this crime over at the Palace Station. And during that, there was comments made by Mr. Simpson. We go back many years to around 1996 when there was a civil judgment, 1997, in the death of Ronald Lyle Goldman. As we indicated to you at the beginning of this case, that is a different case. Those are different facts. That is not your concern or our concern in this trial. But the effect of that judgment is something that you may consider in assessing what you have to do in this case. And the mental state of Mr. Simpson and the actions that he undertook and that Mr. Stewart and the other co-defendants, former co-defendants, undertook on this date in question
record, that was from September 15, 2008, JAVS recording the opening arguments at 9:21:52 seconds and ended at 9:23:20 seconds. Now could you play 5012, please? And that is from the same date at 9:25:07, and it'll be pretty short.
From witnesses in this case, those close to Mr. Mike Gilbert, as well as the defendants, as well as from the defendant himself in the audio tapes, is that back when the judgment was imposed, they got an advance notice that the sheriffs were coming over to take property for that order. And prior to them arriving, because they had this advance notice, they went and took a lot of the property of Mr. Simpson, and they hid it among his friends, Mike Gilbert being one of them.
And then could you go to 5013, which is same day at 9:26:54 seconds, and it will end at 9:28:52 seconds.
It was only a few months before the incident here in Las Vegas in September of last year when Mr. Simpson filled out interrogatories in that civil case. Those are questions that were given to him to have him describe under oath where his property is or if he had any additional property. And there were a number of them, and you'll see those. He was asked whether he could tell the names, addresses, and phone numbers of persons or agents who had any goods or services that were his items, that should be his items. And his response to that was an objection on the grounds that the information requested was burdensome. That was interrogatory number 9. He was asked to describe all personal property that was being held in trust by anybody in the name of another person or another custodian. And his answer to that question was furniture, clothing, and other personal items of little or no value. Those items are located in my home, and then he gives an address in Miami, Florida. And then interrogatory number 13, describe personal property. In any location that you're aware of, he said, I have a life insurance policy, but I'm not sure what type of policy it is. And then he signed those interrogatories under oath on February of 2007, just months before the incident involving all of the memorabilia and property that was taken from that hotel room at the Palace Station on the 13th of September.
Do you recall that opening argument being given and
Yes.
the civil judgment and the interrogatories being displayed as they were in those clips?
Yes.
And do you agree that none of that was admissible under Judge Glass's one and only ruling that had been made on the case at that point?
That's correct.
All right. Do you know why the defense did not object to that coming in opening statements?
The way it worked was, it was Yale's opening. I wasn't doing the opening. Therefore, it was his right or not right to object. I mean, in other words, it was his responsibility. He was lead counsel. I wasn't about to say, you know, if he had some trial strategy that I didn't know about or that he was going to develop and then come through me or with it or whatever. If anybody had to object, he should have objected. He didn't object.
Okay. Would you agree that all of that was character evidence?
Yes. Well, not all of it. I mean, well, I guess it could be considered character evidence. You know, I guess the point they were trying to make was that O.J. saying back then he didn't have any property really to speak of, and now he's saying he does, that kind of thing.
And wouldn't lying on interrogatories be character evidence?
Yes.
And Judge Glass, in fact, determined that when the issue finally was brought to her again with David Cook's testimony.
Correct.
That was her ruling at that time. Look, this is almost other bad act evidence. It's not relevant. It's way more prejudicial than it is probative. and I'm gonna exclude a David Cook's not even testifying.
Right,
I don't wanna hear about interrogatories, I wanna hear about turnovers, right?
right.
And that was also her ruling when it came to Mike Gilbert's testimony. We're not getting into turnover orders, we're not getting into, how you came to have the property.
Correct.
Because it doesn't matter how Mr. Gilbert came to have the property, right?
Yes.
Okay. So, given that, would you have objected to all of that evidence regarding the Goldmans and hiding property and giving false statements in opening statements?
Yes.
All right.
The same way I wanted to object throughout trial to the way Judge Glass was telling us to sit down, and I thought it was just, you know, I remember talking to Brett Bryson about it, and saying, you know, he said, we gotta object, and then Brent ended up filing, you know, doing an objection, but I would talk to Yale and say, Yale, come on, we gotta shut this judge down a little bit, on the record at least. It's an appellate issue with the way she's treating the defense attorneys, because it was pretty bad. It was blatant. And Yale just kept saying, no, we're not objecting. He thought he had like a connection with Judge Glass. He thought he got along with her real well or whatever. We're not objecting to it, and we never objected to it.
Okay. But do you agree that under Judge Glass's rulings, which again were fairly protective of Mr. Simpson's due process right to a fair trial, at least as far as character evidence goes, that if you had objected, she probably would have sustained the objection?
I don't know about that.
Well, the only ruling you had at that point was this
Right,
evidence
but I
isn't
don't
coming
know
in.
how I can't predict what she would have done.
Okay. And then I'd like to play another clip to demonstrate the highlighting you were talking about. And I'd like you to watch that for reference to other bad acts coming up. And do you have the clip number, Josh?
505-2.
Okay, thank you. And this is from file 5, which is the Palace Station prior to the incident, not file 6, which contained the incident, the shorter one.